A few people on the line today. Thank you very much for joining us. So we're at YourLand. My name's Kristian. I'm the sales manager here, and we've got Mark Donaldson, who works with our legal team at Beck Legal. There he is. That's Mark. So you can probably see him in the over on the side of the screen, or however you've got your screen positioned. But so we just wanted to run through. We get quite a few questions on the sales floor from a lot of people, just asking about some of the jargon, some of the terms around the contracts, how contracts work, and a few of the what ifs as well. So we just thought we'd provide a bit of an overview today to you on what some of those things are, the most commonly asked questions that we get, and hopefully it can help a few people out. Bearing in mind, anything that we'll be discussing today is general in nature, so it's not specific information to your circumstances. So please, if you do have any questions, do seek independent legal advice if you are proceeding with a legal contract in any form at all. So we'll start running through this. The presentation that we've got there, main topics, common legal jargon, what do a few of the terms mean, change and uncertainty, what happens if there is a change to circumstances from when I sign the contract to when it settles and even beyond, into the next one there, after settlement. What is there that I'm responsible for following settlement? So legal jargon, Mark, cooling off period. So 3-day cooling off period. Some people ask about it, but it seems as though a lot of people that we speak to don't quite understand it. Can you just give us a bit of a run through about what the cooling off period means, when it's applicable, when it's not?
Yeah, sure. It's a really great mechanism for protection of purchasers going into contracts. The law recognises that people do sometimes change their mind quite quickly after they do sign a contract, and the circumstances when they do sign a contract can be a bit different to anything they've ever experienced before. So the cooling off periods work for all contracts with some exceptions, where you're provided a 3 business day period after you have signed the contract. So that's an important point, not when both parties have signed the contract, but after you yourself have signed the contract, to get out of the contract if you do change your mind. So if that does happen to you, you need to get in touch with your solicitor or the agent directly. There are some pretty strict notice requirements around that. You've got to make sure that you're very clear in your notice back to the vendor and their agent that you want to exit the contract. And in those circumstances, you get pretty much all your money back. There is a small amount that the law does say you need to pay, and that's is indicated on the spreadsheet there, on the slide there. Sorry, that's it's $100 or 0.2% of the price, whichever is more. So you'll end up paying generally a couple of $100 if you're buying a normal residential allotment. It's a small price to pay if you do change your mind, but that is one protection of a number that the law does allow purchasers when they're entering into deals.
Cool, thank you, Mark. And Mark, with the cooling off period, so 3 business days. So we often get a lot of people in the office that sign a contract on a Saturday or a Sunday. So that if they sign on a Saturday, that would take them to, is it 5 p.m. on the Wednesday, or is it midnight on the Wednesday? No,
it's the close of business. So it's at the end of that Wednesday period that you need to have provided your notice. So actually sending the notice is the most important part, and getting that out before the end of that 3rd day. So yeah, in your example there, it would be close of business on Wednesday. So you'd want to be getting in touch with your conveyancer if you have one. If you don't at that point, doing the notice yourself is absolutely fine. But getting it on to the solicitor for the vendor who's named in the contract and their agent is a really good idea.
Okay, fantastic. All right, thank you on that one. Another one we have, Mark, is and/or nominee. So my understanding is that I know particularly in our contracts that there's a mechanism within the contract that means you don't need to write and/or nominee, and that it essentially means it's assumed for the contracts. So can you talk us through what and/or nominee means, and how it works for purchasers, how it can help them?
Yeah, sure. And or nominee is a phrase that's in some ways become a bit outdated. Most contracts that you'll see in any development allow nominations to occur. So in days gone by, purchasers used to write their name in the contract and then write the words and or nominee after it. Strictly, it's not required. You've got a right at law to nominate under a contract. What that means is that you can either add or substitute purchasers to the party who was named originally in the contract. So you may decide on the day that a couple will enter into the contract, and you may get some financial advice before settlement that says it's a better idea if only one of you proceed with the purchase. That may be for asset protection reasons or tax reasons. You then can nominate the contract, and that just involves getting your a form of nomination prepared by your representative and getting that onto the vendor. So it's done between legal officers. It's not done with the agent itself. There are usually, in most developments, and certainly in the YourLand contracts, there are pretty strict rules about how the nominations need to occur and the information that you need to provide. So the identity of the person who's going to be nominated obviously is important, whether they're a family member, whether any amounts have changed hands for the right to take the nomination in the contract. That's another important thing that needs to be disclosed, because the vendor themselves do have disclosure obligations that they need to make to State Revenue Office and the like, so, and potentially their own bank. So the last point on the slide there is really important. As soon as you know that you want to do a nomination, act quickly and let your solicitor know or your conveyancer know, so they can then get in touch with the vendor and the vendor's representative. There is some paperwork that does need to be sorted out, and trying to do that in the day or so before settlement can make things really difficult, and can often mean that a nomination doesn't go ahead. So as soon as you know, act quickly and get in, and it's usually not an issue. There are some circumstances where a vendor won't allow nominations, but they're pretty limited. And as long as you're being upfront and acting early, generally a vendor will have no issue with the nomination.
Beautiful, fantastic. Thanks, Mark. Nice, nice, good, clear, concise explanation there. That's good, because it's a tough one, I think, for a lot of people to wrap their head around. So buyback as well. So I know a little while ago that a lot of developers started putting in a buyback condition within their contracts. Can you talk us through what that actually means for purchasers? A lot of people, I know in my experience, have said that the developer can just come along at any time and buy the block back from me. I know that's not the case, but would you be able to just clarify that for a few people, please?
Yeah, sure. It's got a bit of a stigma about it. It does sound nastier than it actually is in the contracts, the phrase buyback. Essentially, there are a lot of developments out there now, and YourLand's no different, that allow a right for a vendor to buy a property back from a purchaser after settlement. Now, the reason for that is there are some rules around what you need to be doing after settlement in terms of constructing on the land and complying with things like design guidelines or fencing requirements, landscaping requirements, things like that. In very rare circumstances, a vendor will exercise a right to buy back the property where a purchaser has bought the land and then either not built on it or not built in conformity with the rules of the development in particular. I suppose it's a way of the vendor having absolute certainty that everyone's going to comply with the rules of the development. Obviously, when you're buying into a particular development, you're buying in because you like the location, you like the design guidelines and the vision for the estate. And the vendor having a right to buy back is trying to make sure that that's fair for everybody. So you don't have blocks that are left vacant or blocks that are just not conforming at all with the intention of the estate or the stage, pardon me, within the estate. So the vendor, if you're not conforming, will provide a notice to say why you're not conforming, give you a chance to conform. So that means either starting building works or getting on the land and fixing up whatever needs to be fixed up. And in the event of continued non-compliance, then there's that right to effectively buy back the land, less their costs. So you will get your money back, less the out of pockets that the vendor would incur. But yeah, the main point is it's about trying to be fair for everybody and remove parties within an estate who are making it or not buying into the vision that everybody else has bought into.
Yeah, great. And I think the take out from that, Mark, is that it's extremely rare. There's some pretty considerable circumstances that need to occur for it to even be thought of. So it's not like developers can just walk in and, hey, we want that block back. So nothing to be afraid of.
Yeah, no, that's right. And all the developers that we work with will try and work in with parties who aren't conforming and yep. try to get to the bottom of why. If it's a cost thing, if it's a change of people being involved in the lot, developers don't want to exercise those rights. They're there as an absolute last case.
Yep, great. Another one we often get, Mark, is the community infrastructure levy. So it's an extra payment, obviously, that the purchasers are required to pay. Can you talk us through that? There's a couple of figures down there that varies from council to council, but can you just give us a bit of background as to the community infrastructure levy and what it is, what it's used for as well?
Yeah, sure. It's one of these levies that councils actually pass on to purchasers. Most of the development levies that relate to new estates are worn by the developer and the vendors. So this one, though, is a bit different. It's passed on to purchasers and paid to council at the time a building permit is granted. So the idea is that it's supposed to be a contribution towards the broader infrastructure in the estate. It's broadly charged across Victoria by most councils. So the figures that you can see there, you're looking at around the $1,200 now. It's reviewed annually as at 1 July. Wyndham and Melton, who are pretty prominent in the YourLand estates, they're charging $1,210 at the moment per dwelling, and then Kristian is at $1,190. Most are around that level. Some are slightly lower, but yeah, it's a one-off payment. It really needs to be factored in as part of your build costs when you're talking with your builder. So if they're not factoring it in, ask them what the charge will be, so you know broadly what you're looking for.
Great, thank you. So again, I suppose talking about circumstances change. So a lot of people, when buying land off the plan, it can sometimes be quite a little while until the land is settled on or it's completed and you're ready to build on there. So a lot of people ask questions about if their circumstances are changing. So one of them is, if their circumstances do change, can they sell the lot prior to title? Can you just talk us through what generally happens there?
Yeah, sure. This one's probably a little bit trickier than the nominations example that we were talking about before. Selling the block, so advertising it effectively in competition with the rest of the development is a bit more of a sensitive issue for most developers. So the answer to the question really is it's going to depend on the estate and the particular developer that you are working with. The contracts, again, for most developments, including certainly YourLand's, do have very strict rules around how you can do that if you are allowed to do it. So as I was talking about before, the rules around advertising and how you effectively compete in the market with the developer, they are pretty strictly enforced on an ongoing basis. So you wouldn't necessarily be allowed to advertise on the land, for instance, and online listings would need to be reviewed before they're put up. So in those circumstances, it will come down to who the developer is and what your circumstances are and why you want to sell before it titles and you have settled. So you'll need to provide evidence to the vendor's representatives and the agent as to why you're doing this. there'll be probably some requirements in the contract to enter into what's called a resale deed or a nomination deed. So that means that when you've on-sold the property, the party who's coming into the property agrees to take on all the obligations that were in the original contract. So obligations to comply with the design guidelines, for instance, to comply with the restrictive covenants that aren't on title yet. All of those things to ensure that that everybody who's signing into the estate, and that includes subsequent purchases, are playing by the same rules and delivering the same estate for everybody that the division in the design guidelines provides.
Yeah, great. So I suppose the important thing there to note as well, Mark, I know you mentioned it earlier, but get in touch with the developer quickly. So as soon as those circumstances change, letting them know rather than waiting until down the track, until your settlement's there. So the earlier you can provide that information to the vendor or to the developer, the much easier it'll be.
Absolutely.
So again, we spoke there about, can you sell the lot? So if those circumstances change and you can't settle on the lot, talk us through, Mark, if you can, just briefly some of the rules around whether you can get your money back or not. You've paid a deposit, circumstances have changed and you need to get out of the contract, you can't settle on it. Can people get their money back?
Yeah, the answer there usually is no. So it's one of the harder things to deal with in developments, that you have purchasers who are in distress. So the more likely outcome there is no, you won't. You potentially will lose your deposit. But having said that, most developers are very happy to work in with their purchasers. So again, as Kristian's saying, let your legal representatives know as soon as possible if you strike any trouble. So if you think that based on the time frame for when the lot will title, if you're not going to be in a position to settle, getting to your solicitor or conveyancer quickly, let them know why you can't settle. The more detail that a vendor has to consider why you won't be able to ultimately settle, the better. And then it's a process of working in with your legal representatives, the agent, and the other side as well, to see if there is an outcome that you can achieve that is satisfactory for both parties. But the more likely outcome is a surrender of the deposit, either in full or in part. Part of that is that vendors through developments do have pretty strict pre-sale rules, so they need to be satisfying their banks to make sure that the project can proceed. But if you're looking at backing out of a contract, don't just think the easiest thing to do is to necessarily just walk away. There are other options. We've spoken about nominations here in this session. That can be a really useful tool to finding somebody else, and instead of ending the contract, nominating it off to somebody, or as we've just spoken about before, potentially reselling before it settles. So again, before you can do any of that, you do need to make contact with the vendor's representatives and have a chat with the agents as well. Getting all the cards on the table as soon as possible is the more likely way of getting a better outcome.
Yep. Fantastic. Thanks, Mark. So again, so talking around finance, so a lot of contracts subject to finance. People want to finalise their finance before they proceed. So if a contract's subject to finance, can someone get their deposit back during that period?
Yeah, they can. So it's important to check your contract to see what your finance date is. If your finance isn't approved, you then have 2 clear business days after that finance approval date to exit the contract. And again, you need to provide evidence that you've applied for the loan. That's a requirement in any contract. And you've got the notice requirements again, that your solicitor needs to provide a notice to the vendor's representatives that finance has been declined. Providing a letter from your bank is the best way to prove that that's been the case. And if you provide that notice within that 2 business day period at the end of the finance period, 2 business days after the final finance approval date, then you are entitled to your deposit back in full and the contract's at an end. So you again, just getting into contact with your representatives as soon as possible, making sure you're getting the evidence from your bank, and then you will be able to exit. So the last point in the slide there, again, another important one. Finance extensions are quite common, but it's really important that you're very clear with your representatives and that you know that your representatives have actually got confirmation back from the vendors that any finance extensions have been agreed. There are lots of cases out there where purchasers think that they've got a different finance approval date to one than they really do. Simply asking for a finance extension isn't enough. Getting confirmation and an agreement back from the vendor about a new finance approval date is where you need to get to if you need more time.
Yep. Great. Thank you, Mark. So after settlement, so we spoke before about nominating or on selling a lot prior to, but after settlement, can people sell the lot after that? Yeah,
they can. There are some rules in contracts around that, though, and again, they depend on the developer. Once you've built a dwelling on your lot, and provided it conforms with the design guidelines, there's no issue on reselling at all. Where you do need to get some consent is if you haven't built on the land yet and you find yourself in a position where you do want to sell. And the principles around that are really what we've talked about in this session, that the vendors and developers are quite keen to make sure that what is built on the land stays in conformity with design guidelines. If you're going to be selling, you need to tell the developer who you're selling to, so they can get the incoming purchaser to sign up on a resale deed, and that incoming purchaser then agrees to take on the terms of the original contract and will conform with the design guidelines. So, but yeah, the first point's the important one. If you've built and everything's fine, there's nothing stopping you moving on.
Yeah, fantastic. So I think the main takeout from what I'm getting from this, Mark, is it's really, really important early on in the piece, even prior to signing a contract, that you get yourself your own legal representative that can give you this advice and make sure that it's personal. As I said at the top of this is the advice that we're going through at the moment is very general in nature. So if you are entering a contract, make sure you're getting a legal representative to look through it, and they can give you the advice around that specific contract. As we've learned today, quite a few things are different from developer to developer. So can't stress that enough, to get yourself your own independent legal advice. Thank you, Mark. I do appreciate your time today. Next week, next Wednesday, we'll be talking through an overview of the building process with a representative from Dennis Family Homes, and then coming up in future, just filing and decorating the interior, and then a development manager on projects. Who are they and what do they do? Guys, if anyone out there wants to get in touch with us at YourLand, you can hit us up here at the email address melbourne@yourland.com, or can contact Mark and his team